So my specific issue is negative declaratory action regarding the lis pendens effect of such an action, but it's all about how the claims can be compared if there are two or many if they are the same. And let me start with a case. Plaintiff submitted action against the defendant for the compensation of damages caused by flooding event in 2012 in state A. And the defendant submitted objection of lis pendens, stated that prior court proceedings in state B, in which the defendant in current proceedings requested that there is no liability to pay to the plaintiff the compensation for paid insurance for the damages caused by flooding of the insured people's property is an obstacle to proceed the case in state A. The subsequent court has to stay its proceeding until jurisdiction of court first ceased is established. This is the rule of Brussels 1A regulation in cross-border cases. And there are three decisive issues to be proven before staying the proceedings. And this is the identity of the parties, the identity of the claims, and the timely priority of the other proceedings. I won't deal with identity of the parties, although it was clarified in a famous Tatry case, and as well the identity of claims. And here I just pay your attention to the text of Brussels 1A regulation article 929, and where proceedings involving the same cause of action and between the same parties are brought in the court of different member states. So you see the same cause of action in English version. And here is the text of Slovenian Civil Procedure Act. Pending the action, no litigation can be initiated between the same parties on the same claim. So the same claim. And so you see that there are slight differences in different languages, also in versions of Brussels 1A regulation. Wegen desselben Anspruchs, same cause of action, le même objet, el mismo objeto. And here we need to understand the Tatry case, that there is still the same, that the defendant held liable for causing loss and ordered to pay damages has the same cause of action and the same object with the meaning of the article as earlier proceedings brought by the defendant seeking a declaration that he is not liable for the loss. Of course, we see that these claims are identical, and of course my next colleague Ivana will try to explain this terminology and this issue more in details. But however, what happened by these two cases, also Gubiš Maschinenfabrik, negative declaratory action is the obstacle for the later action on performance. So we are now in the research, how we can see this identity of claims if one action is just declaratory action and the other is condemnatory action, condemnatory claim. So we can see that procedural equivalence theory gives the ground also for seeking identity, for comparing identity, but however, so there needs to be the relationship between Leistungsklage, between performance action, that is a little bit more than it is just declaratory action. But however, so there is also the notion mutually exclusive claims. Mutually exclusive claims, this can be followed also on the Slovenian court practice, and the rejection of the first claim automatically means that the second claim is justified, but also if the first claim, negative declaratory action, is granted, so is then the next step to performance action is refused as well. And another problem that we need to address is how can we then start this performance action? Where is the right place to submit the claim for performance? Is it possible to submit counterclaim as condemnatory action in the case where the negative declaratory action is pending? But if we just see what it was adjudicated by European Court, there is McFadden case, but McFadden case doesn't deal. European Court never decided about counterclaim. Here it's only that we see that German court then decided and enabled the counterclaim, and then it was dismissed the negative declaratory action, and the court upheld the counterclaims of Sony Music. This is the other party of the case. So this is now an open issue that probably is not so easy to decide. But however, in Slovenian theory, it was dealt that performance actions is something else, is not the same as declaratory action, but it is certainly true for positive declaratory action, and then it's the next step, performance action. And Slovenian law also doesn't allow declaratory action if there is no interest because the plaintiff already has the claim for payment for performance that is possible to get more extensive more extensive court protection. But just pay your attention a little bit to the claim itself. So what is also the problem? How to create, how to determine the claim with negative declaratory action. Here is just very simple formulation. The court should issue the following judgment. The court shall declare with effect between the applicant and the defendant that the defendant has no claims against the plaintiff in connection with the flood event in 2012 from any legal title or subordinate that the plaintiff is not obliged to reimburse the defendant for the payment of damages and payments of the insurance company in connection with this event, with article of the Code of Obligation or from any legal title. The question is this sufficient determination of the claim? Did the plaintiff sufficiently define the relationship? But I will stop at this point because there are no answers taken by the courts by now, and so I will introduce my co-author of this contribution, Professor Christian Wolf, you all know from Germany, from Hanover, who will continue with his remarks and his commentaries. So thank you for your attention.
Vesna, if we can start with your last slide. Thank you for your marvelous presentation. I think I have only to add very few remarks. I think you raise the most decisive question, and I fear we Germans are not the best speakers about that topic, because we I think we struggle since over 100 years with negative declaratory actions, and we are not able to fit this kind of action in a persuasive way in our legal system. In Germany, if you start a negative declaratory action and you lost the case, we say now it is clear and it is part of res judicata, that now it's clear that res judicata covers the action or the claim of the defendant. Now we know the defendant has a claim against the defendant has a claim against claimant. Saying that, we do not, in Germany, what I think is silly, we do not enforce such a judgment, because we say this judgment has a lack of the judicial enforcement order. But I think that's not a substantive question. It is a technical question which we cannot come over. There is a colleague of mine, Mr. Braun, who taught in Passau, and he has written for all our fellows who can read German a very great book about German civil procedure. He is not in the center. I may show you the book. He's not in the center of the German civil procedure teachers. This is this book. If you can you see it, this is the book, a really huge book. And I think that's the best book about German civil procedure. We all study German civil procedure with Rosenberg, Schwab, Gottwald, but I think the Braun is the state of the art. And he writes in this book that it's quite simple. We just have to redesign the order. The order is not regulated in German civil procedure law. The order is more or less the custom of the court. And if the court not only says we deny this negatory action, but we order that a claimant has to pay to defendant, then everything would be clear. So we in Germany, we really have the problems that we arise a lot of questions in doing in a very bad way to think about negative declaratory judgments. What is more decisive for me, and that makes it more complicated, is the theory of the Streitgegenstand of the European Court of Justice, because this is much broader than we normally in the German or Austrian or Slovenian system use. And I think that's the point what really rises the problem. So for me, it's less the question of negative declaratory judgment, but the question of this point says how we elaborate the lis pendens in the European system, and the lis pendens is much broader than at the very end res judicata. And I think this gap is not yet solved between lis pendens and res judicata in the European system. If you are interested, I can share with you my desktop. Now, maybe Niels Kurt can step in too for me, because these slides are primarily his slides, and we will go through these 4 slides together. Kurt?
I'm here.
Okay, then tell us a little bit about your slides.
Okay.
I have just changed the wordings.
Originally, they were intended to fit in Vesna's presentation, so it's a bit out of order right now, and you have to stop me and ask if it is out of order, what I'm telling right now. So lis pendens, and it was supposed to be the German autonomous interpretation of lis pendens in contrast to the European one. And in Germany, it should be like most of you know, it's the absence of lis pendens, which is a sort of negative requirement to start proceedings in front of a court. So the court has ex officio to check whether there is a matter pending within the same course of action or between the same parties, which has been initiated before the proceedings the court is seized with. And this is regulated within paragraph 261, subsection 3, number 1. Did I forget something?
No, no.
May I jump in?
Pardon?
May I jump in with the question?
Of course.
Sure.
Because I'm curious about the German approach. If there was now an international element, it was just national German case. Is it a negative declaratory action the obstacle for the subsequent, for the later performance action, Leistungsklage, or the court enables also the next Leistungsklage, and the things that, or the text that next Leistungsklage is aliud, is something else, not the same as the negative declaratory action, but just national approach.
We'll give you an answer in our next slide, Vesna.
Okay.
Maybe I going to the next slide.
Shall I go on?
Yeah.
Okay. Vesna, to answer your question, in general, lis pendens of the first action bars the admissibility of the second action. And this also holds true technically for if the first action is a negative declaratory action and the second action is a Leistungsklage, so affirmative relief. However, our negative declaratory action, so the party seeking negative declaratory relief, has to provide a special interest in the negative declaration. So some legal interest, there has to be some danger for some of its legal rights or whatsoever. However, the result of the negative declaratory action, the judgment, is not enforceable except for the costs. So the affirmative relief, the Leistungsklage, provides for more legal protection than the negative declaratory action. And that's why most of German scholars and the German Federal Court says that if the second action is Leistungsklage, affirmative relief, the party seeking negative declaratory action loses the interest in seeking negative declaratory relief. At that moment, the negative declaratory action becomes inadmissible, so there isn't lis pendens anymore, which could bar the second action. And that's why in Germany, the affirmative relief, the Leistungsklage, prevails over the negative declaratory action.
So thank you. I need to finish our contribution so this discussion can follow afterwards. And I'm very curious also for further explanations